Confederation and why they failed. And you saw a little John Green sort of preview of what we're going to be talking about today. So let me share my PowerPoint. Okay. All right, so our country has very few things that sort of tie together the people that live within it. We were not a country that was founded on everyone having been from the same ethnic group or speaking the same language or practicing the same religion. And so political scientists refer to a concept called civic nationalism, whereby what we sort of revere as a country, or are supposed to, are just a few things, including the founding principles of the Republic that are sketched out in the Constitution. Americans started off not being homogeneous, and they became even less homogeneous over time through immigration in the 19th century, and immigration has continued up until now. To this day, to become an American citizen, it is traditional to have to pass a test about the Constitution and American rules of governance. So, you know, theoretically, the Constitution is something that we still are supposed to be familiar with. And it should be noted that the American Constitution is the oldest constitution still in use. The second oldest is Norway's, dating from 1814. The process of constitution making has become really super normal. Anytime there is a change, a major change in governing structure in a country, normally a constitution is written. So there are more than 160 national constitutions extant throughout the world, 2/3 of them dating from after World War II. Okay. Why was it necessary to write a constitution? Well, when we talk about the problems with the Articles of Confederation, you know, clearly things were economically unstable. The Articles of Confederation were very inflexible, with every state having to join together to ratify an amendment, so no amendments were ratified, no power to tax. But even more than that, governing elites, who were the ones in power in the state assemblies and in the Continental Congress, were very concerned that it was becoming anarchic when they looked at, you know, popular uprisings like Shays' Rebellion, and it was thought that the pendulum had swung a little bit too far to the side of democracy. So now they needed to rein it in a little bit. Why have a written constitution at all? It is kind of novel that the United States, you know, decided to write this constitution, but realized that state constitutions had existed since 1776. So they had some experience with setting out these kinds of rules on the local level. And the Articles of Confederation, you know, is a governing structure that's in writing. So they had had one time through setting up this kind of governing structure. But I should also mention to you that in 1787, the framers thought that they were at this historical turning point, that the United States was like in the vanguard of good government, that we were somehow an exceptional nation, sort of divinely smiled upon to set up governance for, you know, the framers' generation of the future. James Wilson, one of the framers at Philadelphia, wrote, "After the lapse of 6,000 years since the creation of the world, America now presents the first instance of a people assembled to weigh deliberately and calmly, and to decide leisurely and peaceably upon the form of government to which they will bind themselves and their posterity." It's important to note, though, that not everybody was on board with the idea of creating a new government that would have more centralized power. Amos Singletary, who spoke at the Massachusetts Ratification Convention, said the following: "Does not this Constitution take away all we have, all our property? Does it not lay all taxes, duties, imposts, and excises? And what more have we to give? These lawyers and men of learning and moneyed men that talk so finely and gloss over matters so smoothly to make poor illiterate people swallow down the pill, they expect to get into Congress themselves. They expect to be the managers of this Constitution and get all the money into their own hands. And then they will swallow up us little fellows like the great Leviathan, Mr. President. Yes, just like the whale swallowed up Jonah." Okay, so not everybody, and especially not non-elites, were on board with centralizing power federally. They feared that it would take away the rights that they had, and especially their wealth. This right here is a painting, a famous painting called Westward the Course of Empire Wends Its Way, or something like that. But it's basically a pro-Manifest Destiny painting from a lot later than 1787. But I put it in here because I think it encompasses the idea that the United States is like poised on the precipice of greatness, and there's some manifest destiny involved in the writing of the Constitution. Questions so far?
So there were framers that had the idea of having state or the government having too much power over its people.
Yeah, mostly not the people at the convention, but more like people at the ratification conventions, which I'll talk about ultimately. The Constitution had to go before the people in some form so that they, under social contract theory, could put themselves under it. And a lot of those people, a lot of the common people, spoke out against the Constitution. The few other people that were not big fans of the Constitution, people like Richard Henry Lee and Thomas Jefferson, were not necessarily engaged in the actual writing of the Constitution. So, they were critiquing it as outsiders. The call for a constitutional convention came from 12 delegates representing 5 states who had met at Annapolis the previous year to try to amend the Constitution, and not enough people showed up. So they called a convention for revising the Articles of Confederation for Philadelphia in 1787. 12 states sent delegates. Rhode Island's legislature at that time was controlled by a sort of radical delegation that really didn't want a constitution, and so they didn't send anybody. But 55 delegates showed up out of the 74 who had been chosen by their colonies. As you saw in the John Green video, nearly 60% had attended college. 9 were from Princeton, 4 from Yale, 3 from Harvard. 34 of the delegates out of the 55 were lawyers. So you can say the Constitution is a document that was drawn up by a majority being lawyers. Merchants and planters were also well represented. The 2 heroes of the convention were George Washington, who every time they were talking about like what the president's role was gonna be, it was pretty much acknowledged that Washington would be the president. And so it was a little weird having him there. Benjamin Franklin was 81 years old, definitely the oldest person at the Constitutional Convention. But Philadelphia was his home stomping ground, and he threw lots of parties for the other delegates, was extremely popular. No official records were allowed to be kept because the framers wanted to be able to talk freely. They didn't want any news to slip out about who had said what, who had taken what position. And how we know what went on is James Madison sat towards the front, and when they took breaks or when they ended for the day, he went home and wrote down everything that he remembered that people had said. So it is only through Madison's notes that we know the details of who said what. Thank goodness for James Madison for sort of not following directions. Votes were taken by state delegation. You needed 7 votes in order for anything to pass. And this meant that there had to be a spirit of compromise. It was not gonna be like the Articles of Confederation where you needed 13. They already knew that was a non-starter. And as I said, Jefferson was not there. He was in Paris, but he was not one of the constitutional framers, although he had been responsible for the writing of the Declaration of Independence. Questions?
Did Washington play a major role in it, even though did he think he was going to be the president?
I think he knew he was going to be the president. He is not listed as having said very much at the convention. Madison did identify who the main speakers were on issues, and he didn't say much. But I think it did kind of shape the discussion of what the presidency should be like to have somebody like him there. And we might want to think about that for a bit. You know, like when they thought of what should a president be, they were thinking of Washington, who had led their troops, you know, since 1775. Somebody in whom they had a huge amount of respect for his personal probity and, you know, his loyalty to the country and everything. So it wasn't like they were just like making up a president out of thin air. They were actually thinking about the guy that they had and thinking future guys were going to be like him. Okay. The Constitution writing was all about compromise. And there are 3 compromises within the Constitution that we should keep in mind. The first one, the Great Compromise, the Constitution would not have come together without. This was a really central issue about what the structure of the government was going to be. There were, at the Constitutional Convention, represented states that really depended on slavery for their labor force, states that did not depend on slavery anywhere near as much. There were big states with lots of people. There were states with a large proportion of enslaved Americans. There were small states that just had fewer people, full stop. So how are all these states, and remember, people are still thinking of themselves as having their first loyalty to their state rather than to some kind of overarching federal apparatus. How is that going to work? Well, the first idea for representation put forth was the Virginia Plan. James Madison, who was the author of this plan, wanted to have 2 houses of government in which both would be proportionally represented on the basis of population. Virginia was a large state, both in terms of its geographical extent and in terms of its population. And so if the Virginia plan had succeeded, Virginia would have outweighed the smaller states like New Jersey and Delaware and Rhode Island, even though they weren't there. William Patterson of New Jersey and John Dickinson of Delaware were given instructions not to back down on the question of representation of small states. So they proposed a one-house legislature with every state having 2 representatives. That was a non-starter from the perspective of the larger states, and then of course Roger Sherman came along and proposed a compromise whereby there are 2 houses of governance, one of which has equal representation by state, and one of which supposedly, or is supposed to, have equal representation on the basis of the population. In fact, it does not. The problem with the House of Representatives is that there is a minimum number of Congress people that a state needs to have. They need to have at least 1. No matter how few people live in that state, they'll have 1 congressperson and 2 senators, say. Whereas in a very large state, they have multiple Congress people, but the worth of each person's vote for Congress is less. I don't know the exact figures, but let's say in Wyoming, every 350 people, no, more than that, every 350,000 people elect 1 congressperson, and in California, you need 700,000 people to elect 1 congressperson. I mean, it's not those numbers, but that's kind of how it works. This is especially true since we've topped out how many Congress people there are allowed to be in Congress. I mean, at first, the Founding Fathers knew that Congress would start off small and then it would get larger depending on how the population moved around. But we have had a limit to the number of Congress people since the early 20th century, and so all that happens is reapportionment. Those seats might move around. If some state loses a lot of population and another state gains a lot of population, Utah was going to lose a seat because so many people were off on missions during the census, but I think they protested, and so that seat, which would have gone to North Carolina, I do not think did. Okay.
But there's no limit on any representatives a state can't have.
No, right. So if, yeah, every state has to have at least 1 congressperson, and that's what makes it problematic. New Mexico gained a 3rd congressional representative at some point in the second half of the 20th century. I should know better how that worked. But we didn't used to have 3 congressional districts, we only used to have 2 congressional districts. But the total number of Congress people in the United States doesn't change. Okay. So without the Great Compromise, without this sort of bartering between big states and small states, the Constitution would not have come together. This was the first compromise that was brokered chronologically. Any questions about the Great Compromise? The second compromise grew out of the first compromise. If we're going to have a census, count all the people, and that census is going to be used for the process of apportionment, that is to figure out how many Congress people you get, well then comes the question, at least from the Southerners' perspective, how do we count enslaved people? Now, from the perspective of Southern slaveholders, enslaved people did not count as people under the law at all. They counted as property. there were many, many aspects of their existence that didn't count them as people. And in fact, states had to pay taxes on 3/5 of the value of their wealth. And that is where that 3/5 number came from. So both sides were discussing, both northern and southern states were discussing how it was that enslaved people should count for the purpose of doing the census. And southerners said, well, they should count as one. You know, they should count as one whole person. And then northerners said, well, how can you possibly argue that when you treat them as property in your legal code? And the southerners came back and said, yes, but they're hard workers. They generate a lot of wealth. They generate as much wealth for the nation as white workers do in the north. And some northerners said, there's no way we're going to let you count, you know, let you have your cake and eat it too, let you count African Americans as both property and persons. And that's how they came up with the 3/5 compromise. The 3/5 compromise does not mean that enslaved people were considered to be 3/5 of a person. In the law in the South, they were still non-persons. They were chattel. But for the purposes of the census, you count all of the free white people and then 3/5 of other persons, excluding Indians not taxed. So the other persons are enslaved people. And that's the number that you come up with for the census. Right away, this gave southern states with lots of enslaved people an electoral advantage in Congress. This shifted over time as the United States moved westward, but at first, the southern states had more congressional representatives than they would have had, many more, had they not been able to count enslaved people. All right, questions about the 3/5 compromise? The final compromise was the Electoral College. This is the reason why our exact form of government doesn't get implanted anywhere else, because the Electoral College has turned out to be very, very problematic. The Electoral College elects the president and then disbands. Each state has as many electors as they have in their combined congressional delegation. So add up the number of senators and the number of Congress people, and that is how many electors there are from each state. And then Washington, D.C. has 3 electors. If there is a majority, an electoral vote majority when the election happens, then a person becomes president. And if there's a tie, what happens if there's a tie?
The Senate, leader of the Senate breaks the tie? No, it's something else.
No, how it works is it goes to the House of Representatives, and they vote based on state delegation, 1 vote for each state. And whoever wins, whoever gets the most votes is the winner. Now, some problems with the Electoral College. People vote, the first problem with the Electoral College is people vote within a state. And let's say in the state of New Mexico, 51% of the voters voted for person A, and 49% of the voters voted for person B. How many of the 5 electoral votes of New Mexico go to person A?
Can you say percentage?
Is it 49 versus 51?
Yeah.
So it'd be 3 to 1 person, 2 to the other.
No,
None?
It'd be great if that were the way that it worked, but no. All 5 electoral votes go to person A, no matter how slim the margin is. So all of those people who voted for person B, no electors go to their person. There were a couple of states where that's not the case. Maine allows electors to be chosen regionally, and so there is, not this winner take all sort of thing. But other than that, most states are winner take all. What this has meant is that in several elections in American history, a candidate who has gotten a minority of the popular vote has gotten a majority of the electoral vote and been elected. When did this happen? It happened in the election of Abraham Lincoln, for example. He only got 39% of the popular vote, and yet he won the electoral vote. It happened in the case of Donald Trump in 2016. He lost the popular vote by something like 300,000, but he had the majority of the electoral votes. And the other weird thing about the Electoral College at this point is that the way that various states have voted over time kind of settles them as either red or blue, so that all the focus in presidential elections just goes to a few swing states that tend to go back and forth. So Pennsylvania, Michigan, Wisconsin, Florida, Pennsylvania. I mean, all of these are swing states. They get a lot of traffic by presidential candidates, and the other states, the states that are firmly red or firmly blue, tend to get a lot less. So.
Is that winner takes all written into the state constitution, or is that?
Yeah, it is. And there's also a concept called faithless electors. Like when the founders set up the Electoral College, the reason that they did so, their stated reason, was to act as a brake on popular opinion. So that in case, I mean, this is what Hamilton, Madison, and Jay worried about in the Federalist Papers. In case there were some demagogue who was very effective at like reaching out to the people, but that person was a bad person, the electors were supposed to be men of such stature in the community that they would say, hold on, no, we're not gonna allow you to elect that person. So that was the original rationale as explained in the Federalist. Now, however, if you are an elector and you choose somebody other than what you're directed to by the majority, the popular vote majority in your state, you can be sued as a faithless elector. This is a Supreme Court decision that just happened in the past year. So there have only been a couple of faithless electors in American history, but even people who think, oh, this is a dangerous person, we shouldn't elect this person, they can't do that now without being sued. Yes?
This is a little bit off topic, but still relevant. So I take a government class, and what we learned is that they taught me that we live in a federalist society. They said, where it's divided between the states and government. But in high school, I've also taken a government class, and they said we live in a democratic republic.
Mm-hmm.
And I was wondering, what is the difference between the two?
Well, they're both true. The system of federalism means that the responsibilities for governance are divided between the federal government and the states. The states are responsible for things like health, welfare, education of the people. And the federal government is responsible for things, or was originally planned to be responsible for things like defense, treaty making, mainly that. And anything that is not officially delegated to the federal government by the Constitution is reserved to the states. So that's the federalism piece. The democratic republic piece is we are a democracy, but we're a democracy where we pick somebody to represent us. That's what the democratic republic part of it is. We're not a direct democracy where everybody gets to vote on every piece of legislation, but rather one in which we are supposed to be vesting our responsibility for governance in our chosen legislators. So that's how that works. That's a good question. Okay. So the Constitution was drawn up by it was called the Committee of Style, and that it was approved by the fall by the people who were present at the Constitutional Convention. And then it had to be ratified. The debate over ratification began immediately. I mean, the Constitution was finished being written in September, and then the question becomes, all right, what does ratification entail? Ratifying harks back to the social contract theory of government. John Locke is the one who proposed this theory, that people join into governments in order to protect their rights and interests. They give up a little bit of their freedom for the safety of banding together and not having everybody try to make their own law. So it was thought, okay, it needs to go to the people, whether that is special ratifying conventions that are called by each of the states, or as in Massachusetts, town halls were set up. Three Federalists, Alexander Hamilton, James Madison, and John Jay, wrote a series of 87 essays that appeared in a journal in New York during the ratification discussion, and they have really sketched out the pro-Constitution side of the debate. So Madison was afraid of the tyranny of the majority. That was his main concern, that the views of the majority would tyrannize over those with minority views. I'm not talking about like ethnic minorities or anything at this point, sort of belief minorities. That is why he thought that a republic was better than a democracy. He thought a republic, like a direct democracy, a republic could be viable over a vast extent of territory like the United States had at that point. He thought representatives in a republic system were likely to be the best people for the job, that people would not select legislators who were corrupt or provincial. He rejected the idea of term limits because people should receive training and become more and more like measured and smart as legislators as they go. And one of the most important things that the Federalists believed is in the preamble to the Constitution. The preamble starts, "We the people." And so what they were saying there is that the sovereignty, that is the final power to govern, lies in the people, not in the states. The Articles of Confederation had very clearly said the states have the sovereignty. In England, under the monarchy, the king had the sovereignty. In the constitutional structure, the people had the sovereignty. The Federalists, in turn, claimed, no, the states have the sovereignty. I mean, the Anti-Federalists claimed the states had the sovereignty. Because government was by the people, the Federalists thought there wasn't any way that you could really give the federal government too much power. Because scratch the government, and underneath it is the people. We are the government. So the pendulum for them had swung away from fear of centralized government towards, hey, it's fine because we're the sovereign ones. And this is also a reason why the Federalists didn't think we needed a Bill of Rights. They thought, hey, you know what? If we write down, here are the rights we have, then we're saying any rights that we didn't write down, we don't have. So let's not write a Bill of Rights, and therefore we have all the rights in the world. The anti-federalists, the people who were against ratifying the Constitution, were not on with that. They thought, oh, this is, sophistry. All right, so the anti-federalists, including Jefferson and also Richard Henry Lee, who was the author of the closest thing we have to the opposite of the Federalist Papers, it's called Letters from a Federal Farmer. They said, rather, executive abuse of power was still a big problem. We need to have a theory of legislative supremacy. That is, Congress needs to be more powerful than the president. They said only states really know what the people's experience is, rather than a federal government. And they also objected to the concept of a president as it was enumerated in the Constitution. There weren't any term limits initially on the president. And it was feared by anti-federalists that a sort of monarchy would develop if there were no limitations. Edmund Randolph, for example, one of the anti-federalists, said the presidency was the fetus of monarchy. Actually, Alexander Hamilton was just fine with the idea of having a constitutional monarch, so there's something to that. Sure.
So you said, so Jefferson, he wasn't just not present for the Constitution, he was actually against it.
Jefferson was a states' rights believer. He got a little bit more comfortable with the Constitution after the Bill of Rights. The first 10 amendments to the Constitution were proposed. But the funny thing about Jefferson, as we'll see when we get to the week about his presidency, is he ends up becoming less of a strict constructionist of the Constitution due to pragmatic things that happened during his presidency. So he got the opportunity to purchase the Louisiana Purchase. It doesn't say in the Constitution that the president can double the size of the United States, but Jefferson was like, it's a good opportunity. So he changes his mind.
What was the idea on the Federalists for term limits? The Federalists kind of sound like they were career politicians, like this is going to be something you're going to become, get better at.
Right, the Federalists didn't want any term limits, and there were no term limits specified in the Constitution, although the Articles of Confederation had, very strict term limits, and the anti-federalists were in favor of term limits. But they didn't get a chance to propose any because that was immediately not part of the conversation at the Constitutional Convention. All right. What is new about the Constitution? Well, first of all, constitutional supremacy. The idea that the Constitution is the overarching law of the land, and that any law that conflicts with the Constitution, if there's repugnance there, if the two of them don't match, it is the lesser law that crumbles, not the Constitution. Number two, the location of sovereignty in the people versus the states, which I just said. Number three, taking a page from the French Enlightenment thinker Montesquieu, the constitutional framers decided they wanted a balance of powers among various different branches of government so that nobody would have excessive power. So you guys know the three realms are the judiciary, the executive, and the legislative branch. And each of those branches has a check on the other. Right now, we're in the part where the executive branch and the legislative branch together have a check on the judiciary, in that the executive is in the process of nominating somebody to serve on the Supreme Court, and that person needs to be approved, they need to be confirmed by the Senate. The judiciary, in turn, has a check on the legislature. It is a check that they kind of gave themselves the power of. But it comes logically from the notion that if a law is passed and it's repugnant to the Constitution, then it must be unconstitutional, and somebody needs to be the judge of that. So the judiciary can declare a law unconstitutional. This power is called judicial review. We saw in the past year that the legislature has a check on the executive. What is the legislature's check on the executive?
Impeachment.
So impeachment and removal from office are the check that the legislature has, one of the two checks that the legislature has over the executive. If the president commits high crimes and misdemeanors, Congress, that is the House of Representatives, brings charges like a grand jury, and these are articles of impeachment. So to be impeached just means that the House of Representatives successfully voted on these articles of impeachment. It's like, yes, the grand jury found that you must now go to trial. And then there is a trial. The trial happened in the Senate, and it was presided over by the Chief Justice of the Supreme Court. And then that trial did not remove the president from office. There have been 3 presidents impeached in American history: Andrew Johnson, Bill Clinton, and Donald Trump. A 4th president was on the verge of being impeached when he resigned. Nobody has ever been removed from office as a result of impeachment. And in the case of Clinton and the case of Andrew Johnson, there was a very small margin by which the person hung on to power. Actually, in the case of Trump, there was a pretty small margin too. So theoretically, that check exists. In actuality, nobody's gone all the way through with it. I guess maybe you could count Nixon as an example of how it works in practice, because he resigned rather than be removed from office. Another check that the legislature has over the president is to override a veto. When the legislature passes legislation, it goes to the president, and the president can either sign it or veto it, or he can hold on to it and not sign it, in which case I think after 10 days it becomes law. But if the president vetoes it, it goes back to both houses of Congress, and if they have a supermajority, they can override the president's veto and the legislation becomes law. All right, so I've given you some sense of the way in which theoretically the judiciary, the executive, and the legislative all counterbalance each other. And I want to say too that before the judiciary gave itself the power of judicial review, the idea was that Congress would never knowingly pass a piece of legislation that was repugnant to the Constitution, or that if they did, the president would never knowingly sign a piece of legislation that was repugnant to the Constitution. The framers had a lot of faith in the people that they imagined representing the country in the future. And a lot of what they assumed about people created a series of norms about how we all as Americans behave. politically. And it turns out that those norms are pretty weak. So that is a problem. Okay, House of Representatives was elected by the people. The Senate originally was chosen by the states. Each state legislature chose the senators for that state. So only the House of Representatives was truly representing the people. This changed with an amendment in the early 20th century. The president's role was not only to execute the laws faithfully, but also to be a kind of important figurehead in a world where everybody except the United States was a monarchy, pretty much. And one of the things that was discussed was how should this president be addressed? Somebody said perhaps he should be called Your Excellency, or His Highness, the President of the United States. Ultimately, they just stuck with Mr. President. But the first president, George Washington, still had many activities that he did that were similar to European kings. So he would travel around in a coach in which the coachmen were all dressed in livery, that's fancy clothes with wigs on. He would have a levee once a week where he would dress in his formal clothes with a sword at his side and, greet people who walked into the house of the president. He was paid more than almost anybody else in the United States at that time. It was the equivalent of $25,000. So that made him one of the 6 wealthiest people based on his income. All right, the Supreme Court in the case of Marbury versus Madison in 1803 explicitly set out the power of judicial review that it has. Ever since then, the court has been acting on that power, so that's probably not a power that anybody is going to roll back. The judiciary, though, includes not just the Supreme Court, but also a slew of federal judges whose job it is to decide in federal cases. So there are hundreds of federal judges that are also set up by this Constitution. And then finally, a Bill of Rights. And where the Bill of Rights came from was the ratifying conventions. The Anti-Federalists in their town hall meetings and ratifying conventions said, we're not going to vote for this Constitution unless you make some changes. There are some protections that we would like to see. 212 suggestions were forwarded to James Madison by the ratifying conventions, and he boiled them down to 12, 10 of which passed right away, one of which had something to do with Congress voting itself a pay increase, and that one didn't pass until either the late 20th or early 21st century, and the 12th one didn't ever pass. But the first 10 amendments are called the Bill of Rights. Okay, so the Bill of Rights, there were bills of rights in the state constitutions, and some of these rights that we have in the Bill of Rights came from the Declaration of Rights in England. But they were all sort of cobbled together from requests that Madison got. We can talk about a couple of them. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. All right, so what is guaranteed there in the First Amendment?
press speech, protest.
Yeah, the freedom to protest, the freedom to speak. It says Congress shall make no law. So does that mean that, I don't know, Facebook can't regulate what goes up on its pages? No. Does it mean that Twitter can't kick people off? No. It doesn't guarantee anybody a platform. It just says Congress shall make no law restricting the freedom of speech. So if, for example, Congress tried to pass a law saying that it was against the law to, I don't know, criticize the president, that would seemingly be repugnant to the Constitution. I got news for you though, Congress did just that in 1798, and we will get to that when we get to that. Let's look at number 2. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Okay, what does that amendment mean?
The states have the rights to have their own regulated militia if it was to the federal government to over-infringe their rights.
Right. In the Constitution of New Mexico, for example, it says that the governor can establish a militia, but there's a procedure for that. So it's not like a self-constituted militia. The governor says, okay, fine, we recognize that you're the militia. A lot of times when people read the Second Amendment, they just ignore everything before the comma, which is interesting.